I think we can start. Our president is very much keen on punctuality, and welcome everyone. Good day to you all. Mirdita, dobar dan. Welcome to the first press conference of the president of the Kosovo Specialist Chambers, President Ekaterina Trendafilova. This is her first media appearance since she has taken office, and she is a really distinguished legal professional, but you can find her biography on our website and also is to be distributed in the background. So without further ado, it is my pleasure to announce our Madam President, the Judge Trendafilova, to give her statement.
Thank you very much, Avis. Good afternoon, ladies and gentlemen. I would like to express my sincere gratitude to you for attending this press conference I give as President of the Kosovo Specialist Chambers. I attribute your presence here today to the importance you give to this newly established institution and its activities undertaken so far. Being attentive to this, I will provide a short statement and will leave time for questions that you may have in regard of the specialist chambers. Since I was appointed, I gave priority to and employed all efforts in the preparation of a fully functional legal framework for the specialist chambers. Now, after a lot of work has been done by me and by my colleague judges in this regard, I gladly meet you, ready to answer any questions that you might have. As you all know, the specialist chambers were created with the adoption of the law on the specialist chambers and specialist prosecutor's office by the Parliament of Kosovo on the 3rd of August 2015. The law draws lessons from the experience of other courts and tribunals dealing with similar crimes. It also provides for innovative measures to ensure effective and fair proceedings, transparent as well proceedings, before the specialist chambers, such as the rigorous selection process of judges, the need for rules on the assignment of judges to specific proceedings, the review by the Specialist Chamber of the Constitutional Court of the adopted rules of procedure and evidence. Prior to the adoption of the law establishing the Specialist Chambers and the Specialist Prosecutor's Office, in early 2015, a planning team for the Kosovo Specialist Chambers started its work in Brussels with the aim of preparing the opening and the future operations of the institution. This team was composed of a very limited number of individuals, of professionals, but highly qualified and motivated. It was headed by Dr. Fidelma Donlon, who is today the Registrar of the Kosovo Specialist Chambers. The planning team was able to reach several significant milestones. More specifically, it took in place together with the European Union the financial and organizational framework of the specialist chambers. Later, in mid-June 2016, the Special Investigative Task Force was transformed into the Specialist Prosecutor's Office to carry over its mandate. And on the 1st of September last year, Mr. David Schwendimann was appointed Specialist Prosecutor. On the 14th of December last year, I was appointed President of the Specialist Chambers by the appointing authority, Ms. Alexandra Papadopoulou, who is head of EU Rule of Law Mission in Kosovo. She acted upon the recommendation of the independent selection panel in charge of an independent and thorough vetting selection process. I took up office on the 12th of January this year. Eventually, 19 judges were appointed on the 7th of February this year. The selection process, as provided by the law, is a novelty for the selection of international judges. It was conducted by an independent selection panel composed of 3 international members, 2 of whom were international judges with substantial international criminal justice experience. The knowledge, experience, expertise of the candidates as legal practitioners, be it as judges, prosecutors, or defense lawyers, was thoroughly tested. The purpose of this stringent and strictly professional selection process was to ensure that the most qualified and committed professionals be appointed, as well as to prevent any political or other interferences. The high caliber of the judges placed on the roster attests to the nature and the purpose of the selection process. On the roster there are judges who have served with international or internationalized criminal courts or tribunals, or with European Court for Human Rights. There are judges with distinguished domestic careers, be it as judges, defense counsel, or prosecutors. There are also judges with outstanding academic careers in the legal field, renowned for their profound knowledge and unique expertise in the field of criminal law, humanitarian, human rights law. Others possess vast experience in administrative law. Since the appointment of judges has been completed, much has been achieved by the specialist chambers. Within only 1 month upon my arrival, 3 documents were prepared and sent to the judges. I have set up a strict and meticulous working plan with stringent deadlines agreed upon by all my colleagues. Judges provided comprehensive comments and proposals to the drafts that they have received. The updated drafts were then discussed at the first plenary held in mid-March over the course of only 4 days. During this first plenary, the Code of Judicial Ethics and the rules on the assignment of judges were adopted and immediately entered into force. They are available on the website of the specialist chambers. I will briefly address the nature and importance of these documents. The rules on assignment of judges sets out the basis upon which the President assigns judges to specific proceedings. Such rules on assignment of judges have not been applied to international judges so far. Thus, they represent, the rules, a novelty established by the law as adopted by the Assembly of Kosovo. The rules dictate that for each assignment to specific proceedings before the specialist chambers, the President shall be guided by criteria such as experience, expertise, seniority, gender, and geographical representation. And accordingly, the President should issue a reasoned decision explaining, justifying the assignment of particular judges to specific cases. Preferences and availability of individual judges at the time of the commencement of specific proceedings must also be taken into account, as judges are not permanently assigned. They are not present at the seat of the court. The Code of Judicial Ethics regulates the professional standards applicable to judges of the specialist chambers. It sets the highest professional standards of independence, impartiality, integrity, and diligence for the judges of the specialist chambers in carrying out their functions. Further provisions are included regarding obligations of confidentiality, courteous conduct during proceedings, respect for staff members and participants in the proceedings, and also communication with the media. Very importantly, and in an unprecedented fashion, it also provides for disciplinary measures in cases of misconduct on the part of the judges. Serious misconduct and misconduct of a less serious nature are unequivocally defined in the Code, thus setting the bar for the judge's conduct. A detailed procedure is provided for any such allegations, and crucially, concrete sanctions are regulating, ranging from formal and written admonishment by the plenary to actual dismissal of judges from the roster of the specialist chambers. I have to confess that I am proud that all the judges have achieved consensus on such an important document which the plenary adopted before the inception of our judicial functions, which is not always the case with other institutions. After the adoption of these two documents, the plenary proceeded with its work on the rules of procedure and evidence, and the 4 judges assigned to the Constitutional Court chamber did not take part either in the discussions and also not in the adoption of this document. The rules of procedure and evidence regulate the conduct of criminal proceedings before all levels of the specialist chambers. They set out, amongst others, the procedure for reviewing and confirming or declining to confirm the indictment, disclosure, presentation, admission and assessment of evidence, deliberation and pronouncement of judgment, participation of victims, and matters relating to cooperation with Kosovo authorities and third states. The rules also provide for a very robust system for the protection of witnesses, victims, and other persons at risk on account of their cooperation with the specialist chambers or on account of the witness testimony. Overall, the rules of procedure and evidence aim at enhancing the fairness, expeditiousness, efficiency, integrity, and security of the proceedings, while complying with the Constitution of Kosovo and international human rights standards. By adopting the rules of procedure and evidence in less than 2 months after their appointment, the judges have demonstrated their professionalism, outstanding knowledge, and relentless commitment to efficient and fair proceedings before the specialist chambers. I take this opportunity to thank once again all my colleagues for their concerted efforts and thorough contributions. In accordance with the law, the adopted rules are subject to the comprehensive scrutiny of the specialist chambers of the Constitutional Court, which is the final authority to decide on the compatibility of the rules with Chapter 2 of the Kosovo Constitution and universal human rights standards. Thus, the review of the Constitutional Court chamber is of particular importance and its role is crucial. The Specialist Chamber of the Constitutional Court had 30 days, as provided by law, to take its decision, which was rendered last week on 26 April. In its decision, the Specialist Chamber of the Constitutional Court declared that out of 208 rules, only nine, I would say, were not consistent with Chapter 2 of the Kosovo Constitution. With regard to one, it was unable to make its determination. I will now briefly address these provisions. Rule 19 provides for the possibility to hold hearings in the absence of one of the 3 judges normally sitting on the bench, for example, for healthy reasons, family reasons. And the duration of the absence was up until to 5 days. This rule was designed by the plenary to respect the right of the accused to be tried without undue delay, another very important, fundamental, universal human rights accorded to anyone brought to account. It was, however, found to be incompatible with the Constitution because allowing for this temporary absence of one judge and hearing before two instead of a full panel of 3 judges would not constitute a proper hearing, and here I dictate the law, I quote the law, before a tribunal established by law, as prescribed by the Constitution. Next, the specialist chamber of the Constitutional Court found that a set of rules that was regulating the special investigative measures to be conducted by the specialist prosecutor need more specificity and safeguards ensuring the rights of individuals. Next, Rule 54, paragraph 4 deals with the release of a person to the territory of a third state. The specialist chamber of the Constitutional Court found this rule to be incompatible with the Constitution because, as it stands, the release of the detainee appears to depend on the consent of the third state. Finally, Rule 158, paragraph 2 provides for the possibility to detain a person who has been acquitted by a trial panel while an appeal by the prosecutor against the acquittal is pending. Although this approach is known to international tribunals, courts, and domestic judicial systems alike, it was found to be incompatible with the Constitution because it is not foreseen by law and does not fall under one of the permissible grounds for deprivation of liberty. Overall, anyone reading the specialist chamber of the Constitutional Court judgment will come to realize that in no way was there a flagrant violation of the Constitution, but rather the specialist chamber of the Constitutional Court judgment addressed very technical points that provide additional specificity and precision to the rules. Having said that, I should emphasize that the review of the specialist chambers of the Constitutional Court and its findings is in no way diminishing the quality of the work performed by the plenary. It is not unusual that legislative documents are subject to a strict scrutiny and thereby they are strengthened. This is another proof and assurance of the professionalism, independence, and impartiality with which the proceedings before the Kosovo Specialist Chambers will be conducted. The judges of the Specialist Chamber of the Constitutional Court strive to ensure that the highest human rights standards are upheld, which was also the ambition of the rest of the judges, of all of us during the plenary when contemplating and adopting the rules. Therefore, we all welcome the decision of the judges of the Specialist Chamber of the Constitutional Court, which will help us to finalize the rules in accordance with Chapter 2 of the Constitution of Kosovo and in conformity with the high standards of international human rights law. I reiterate our gratitude for the commitment of the judges of the Specialist Constitutional Chamber, for their commitment in undertaking their task conscientiously and with utmost professionalism. Now, as prescribed by law, these distinct rules will be sent back to the plenary of judges for revision. I have already, immediately after having received the judgment of the Specialist Chamber of the Constitutional Court, started organizing the work. So in the course of May, we are going to discuss and to adopt during a second plenary in a very expeditious manner the necessary revisions to these rules, and they will be sent to the Constitutional Court, and hoping that after the confirmation of the work that we will do during this second plenary, the rules of procedure and evidence will enter in 7 days thereafter. As soon as this is the case, the specialist chambers will be fully judicially operational, meaning that we can be able to receive filings of any relevant kind and conduct criminal proceedings. In the meantime, the specialist chambers and the registry, we proceed working expeditiously on setting out further more detailed internal regulations stemming or related to the rules of procedure and evidence in order to achieve a fully functional legal framework. In conclusion, I would like to state that in all my undertakings so far, I am driven by the strong motivation that our institution abide by the highest standards in the legal field, that we establish best practices, that we provide high-quality judicial decisions and perform our functions with utmost professionalism and integrity. I am particularly content that this is also the motivation of all my colleagues. I feel especially privileged to be president of the Kosovo Specialist Chambers. The position of president is a tremendous responsibility, which will serve as a strong driving force in the performance of all my duties, in particular to ensure that the specialist chambers will efficiently, expeditiously, and economically dispense justice, independent from any interference, while safeguarding the security and safety of witnesses and the fundamental rights of those brought to account. Thus, my goal and the commitment of all judges is to establish the Kosovo Specialist Chambers as a solid, reliable, and just institution, and I'm honored that the leadership of this task was entrusted to me. Lastly, I emphasize my sincere gratitude to and appreciation of the importance that the media afford to the mandate, functioning, and achievements of the Kosovo Specialist Chambers. The media has a vital role to play in contributing to the publicity and awareness of the proceedings before the Specialist Chambers. Therefore, it is my commitment as President of this institution to be available to update you on our activities. I am convinced that reflecting accurately, fairly, and impartially on our work is crucial for the Kosovo Specialist Chambers, for the general public in Kosovo, in the region, and internationally. Having said this, now the floor is over to you to ask any questions that you might have with regard to what we have done so far. Thank you.
Thank you, Madam President. Just to say that highlights of this statement will be available after the press conference in hard copy, and of course we will send them as a press release. Also, they will be available on our website. So now let's take your questions. Of course, as it is a standard, before you do so, please introduce yourself. Our colleague will be here with the microphone, so please, if you can wait for her for the microphone, and we will be taking a few questions at a time. Thomas, please. Okay. Mm-hmm.
Thomas Fairfuss, Journalists for Justice. I've got a question about Rule 54 of the Rules of Procedure and Evidence. Madam President, it is a generally accepted rule that it is up to judges to decide if a person should be in detention, no matter if we are talking about a convicted person or about a suspect during pre-trial detention or during the trial itself. It's only up to judges to take this decision if detention is necessary or if a conviction is warranted. And this rule is, of course, systematically applied when we look at national courts that have a territory to release a suspect to, or to release an acquitted person to. In the years since 1993, when modern international criminal jurisdictions started to operate, we have seen instances of suspects of which trial chambers said there was no necessity to keep them in pretrial detention because they had surrendered voluntarily and they constituted no danger to victims and witnesses. We have also seen people acquitted by international or internationalized jurisdictions. A few hundred meters from here at the International Criminal Court, a Congolese citizen was acquitted by the judges, found innocent, or the judges found there was not sufficient proof to convict him. And then he was immediately again arrested by the Dutch authorities because they claimed he was illegally on Dutch territory. I do not see what exactly the problem was that the Constitutional Chamber had with Rule 54 in its original form and how the plenary is going to amend it. But I wonder if you could elaborate in general on what will happen if the Kosovo Specialist Chamber's judges find that a suspect has not to be in detention before or during the trial and the Dutch authorities refuse to let him reside in freedom on Dutch territory. And what is going to happen if a suspect is acquitted after trial or after the appeal? Are situations possible like at the International Criminal Tribunal for Rwanda, where former suspects that have been acquitted at appeal have been living in safe houses for years with no place to go?
Very interesting question. Shall we take more, or do you want to? Okay, let's take one more, please.
I can respond immediately,
okay, sure.
Because I have been working at the ICC that Mr. Perfus is referring to, and there are many cases, like the Bemba case, when I took the first decision for the release of Mr. Bemba. Thereafter, he wanted to be released to the territory of 7 states, and none of the states wanted him on the territory. Then the appeals chamber reversed the decision, stating that if the suspect cannot reside on the territory of any of these 7 states, the person cannot be released. Thereafter, we used to have, I know very well, you're referring to the case of Mr. Ngujolo Chui. So this is, I'm not going to go into this because I was sitting also on the appeals of Mr. Ngujolo Chui, but I will, taking heed of what you have said, I will refer to our legal framework. And this is very well regulated in the law and also in the rules of procedure and evidence, such a scenario. And there is a special provision also in the law. When I was reading for the first time the law, I immediately realized that there is a kind of a link between the Ngujolo Chui case when he applied in the national proceedings seeking asylum and so on. Because there is a provision in the law on the Specialist Chamber, Specialist Prosecutor's Office, which dictates that any person released cannot be released on the territory of the host state, maybe preventing that there is in some way interference in national proceedings conducted before Dutch institutions and the judiciary. In our case, if the person will not be able to be released on the territory of the Netherlands, then the person has to be released if the person has resided in Kosovo before having brought to the premises here at The Hague, or to some other state when the president has to go into negotiations and discussions. The same will be also the task assigned to the relevant chamber that is going to deal with this case, releasing the person. And if there couldn't be an agreement on the part of any state, then the person will be sent back to the final country from which where he was residing. That is what the law says. But this is a little bit complicated matter, which has its roots in some previous experience that other institutions who are housed here in this country has created some problems with regard to national proceedings. But that is how we are going to proceed, because this has been quite thoroughly regulated by law.
Okay, thank you. Next question. Yes, please.
Bakrizane, Deutsche Welle. So I would like to ask...
I didn't hear your name, excuse me.
Bakrizane, Deutsche Welle from Germany. In Kosovo there is a lot of speculation about names, about like a President Hashim Thaçi or Parliament's President Kadri Veseli or another names. Do you have at this moment any name, or do you can tell us in what time you are going to start with the first process?
Well, thank you very much, Mr. Tsani. This is an important question, although you understand very well that in any judicial system the triggering force is the office of the prosecutor. And I wouldn't like you to think that I'm evading an answer to a question. I'm known to be a very focused, to the point person. For the moment, there is nothing that I can share with you. Because it is up to the prosecutor to decide when the prosecutor is going to file indictments. Of course, the chambers will quite soon be fully operational, and we will be able to receive any filings. And of course, I would like to further on clarify that judicial proceedings before the specialist chambers can commence not only with an indictment to be filed with the office of the specialist prosecutor, but, and I'm simply referring to the law. The law provides for special investigative, unique investigative measures that the prosecutor might seek, also protective measures for witnesses. So far, there is nothing of this kind, and if there would be an activity, maybe it wouldn't be able that we share this with you, but this is not the case right now because you know that there is also confidentiality, so this is a complicated issue. But my answer now is the prosecutor has not brought so far anything, and it is within his absolutely independent domain to take this decision. What is important is that we have established the legal framework, hoping to be in a short period of time absolutely ready. With the rules, because the rest is ongoing with internal documents as well. And as soon as the prosecutor is ready, there wouldn't be any impediment with regard to the legal basis on which the prosecutor could proceed.
Thank you. Next question. Yes, sure, Thomas, of course.
There have been trials in The Hague before against the category of people that many expect will be the kind of people which will be indicted before the Kosovo Specialist Chambers, namely people formerly part or affiliated to the leadership of the Kosovo Liberation Army. When we saw those trials at the ICTY, they ended in an acquittal, and it was stated both by the Office of the Prosecutor and by the judges during the oral summary of the judgment that this acquittal may very much be due to witness intimidation. If the same category of people is indicted here, are there any lessons you have learned from those trials that went wrong at the ICTY, where even the judges said that due to these security and intimidation concerns, the prosecution could not bring the evidence it might otherwise have brought? Have lessons been learned since then and new security measures implemented here?
Well, thank you very much, Mr. Verfus. Of course, the issue of witness intimidation and accordingly of the necessity of a very, very serious, robust protection of witnesses has been an issue with domestic and also international institutions, and this has happened not only with regard to the two cases before the ICTY against Mr. Limay and Mr. Hiradinaj, but also at the ICC. We all know the developments of some cases there as well, and before other international tribunals. That's why and not only because of the end result of these trials, but also because justice cannot be achieved, cannot be dispensed at sacrificing the life of anyone, be it a witness, be it a member of the family of the witnesses who might be at a very, very serious risk on account of the testimony provided by a member of their family. That's why we have provided in the legal framework upon which we are going to conduct our proceedings a very robust protective protective measures for the protection of witnesses. Of course, we are going to implement the quite common protection, like using pseudonyms, anonymous witnesses, a private or closed session distortion face and voice, and also there could be many other measures to be taken, witness protection program. So this is one of the priorities for us when we have been drafting the rules of procedure and evidence, and this is a very important, of utmost importance priority, which is on the top of everything that we have identified so far, that requires a very special attention, also with regard to witness of sexual and gender-based violence, elderly witnesses, children. And a lot is going to be done on the basis of the legal framework in our practical activities. But everything, of course, will depend on the specific circumstances, because it's good to have the law as such with all the varieties of protective measures to be applied, but at the end of the day, what especially will be applied to a specific case, to a specific witness, to a specific person at risk, will depend on the specificity of each case. It will be really premature, and I cannot speak about this. I know how it is done. We have always to be very meticulously assessing all the situation. Even I remember, I'm sorry, I'm referring to my experience at the ICC in one of the cases, while the hearing was ongoing, the representative of the registry came to the bench and wanted that we give a short break, because one of the witnesses that has testified the previous day before the bench was already the plane in the air, and the family has received threats to put on fire their house and to attack the whole family. So we immediately had to take measures. So this is my example with regard to the specificity that is going to make concrete the protective measures otherwise provided in the law, in the rules of procedure and evidence, of course, in the law as well.
Thank you. Next one. If there will not be any questions, we will be taking it as a sign that the statement was very clear and that everything was explained properly and very clearly on the side of our President. If there are not any more questions, I will close this press conference. I will thank you for your arrival here. Thank you for your attention, and please know that you can always contact us if you have any further questions on the work of the Kosovo Specialist Chambers.
Thank you very much.
Thank you.
Thank you. Have a good day.